Global happenings today. We communicate. We analyze global news.
Hello, great people. Welcome back to our channel. We are so excited to have you again. Fresh update has come up as it has to do with Nnamdi Kanu's case. And this time around, he is filing a fresh case. And the fresh case he's filing is kind of have some relationship with the letter that was sent by Bruce Fein, his international counsel, international lawyer, to James Omotosho. And interestingly, what both of them are buttressing, they are shifting focus from evidential challenges which the federal government is leveraging on to the foundational legality of the charges itself. Foundational legality. On the part of Bruce Fein was talking about the fact that he was extraordinary rendition to Nigeria, which is outrightly wrong according to international law. While on the part of Nnamdi Kanu, he is talking about the fact that that's his new case. A new filing is saying that there is no crime to answer because the law used to charge him is no longer in existence. But let me give you full details and also summary of what this new filing actually captured, and there is possible indication that it may go his way, but I'm not trying to predict what the court will do, but just listen to me as I take you through the whole news. And so now, according to the news, the embattled leader of the indigenous people of Biafra, Nnamdi Kanu, has filed a fresh motion before the Federal High Court in Abuja seeking the dismissal of all charges filed against him by the federal government and his immediate release. In a motion dated October 30, 2025 and titled Motion on Notice and Written Address in Support, Kanu argued that there is no valid or extant legal basis for his ongoing prosecution. He described the case as nullity ab initio, that's void from the beginning, and urged the court to strike out all the counts, contending that they violate constitutional and procedural law. They reported that Kanu, who represented himself in the fresh filing, said his trial offense, Section 1, Subsection 3, Section 6, Subsection 6b, and Section 36, Subsection 12 of the 1999 Constitution as amended, alongside relevant provision of the Evidence Act 2011 and the Terrorism Prevention and Prohibition Act 2022. He maintained that the prosecution reliance on repeal laws, including the Custom and Excise Management Act, replaced by the Nigerian Customs Service Act 2023 and the Terrorism Prevention Amendment Act 2013, which has been repealed by the TPPA 2022, rendered the entire process invalid. In his words, he says, there is no valid charge against me under any existing law in Nigeria. The prosecution is relying on repeal and non-existent law. The charges are a nullity ab initio for want of any extant legal foundation. The IPOB leader cited the Supreme Court decision in FRN versus Kanu, insisting that the lower court are bound to take judicial notice of repeal status under Section 122 of the Evidential Act or Evidence Act 2011. He argued that any failure to do so would make all subsequent proceedings void and unconstitutional. In his words, he says, once a law has been repealed, no court of law can continue to rely on it. Such proceeding offends Section 36, Subsection 12 of the Constitution, which forbid the trial of a citizen for an offense not defined under existing law. Kanu further contended that the alleged offense was said to have occurred in Kenya outside Nigerian's territorial jurisdiction. Relying on Section 76, Subsection 1d, the third one of the Terrorism Prevention and Prohibition Act 2022, he said such act require validation by Kenyan court before a Nigerian court can assume jurisdiction. According to him, the omission violated Article 7, Subsection 2 of the African Charter on Human and People's Rights and nullify the court's extraterritorial jurisdiction in his case. Kanu maintained that any judicial act or legislation inconsistent with the Constitution is void under Section 1, Subsection 3 and Section 36, Subsection 12 of the 1999 Constitution. He cited landmark decision including Aoko versus Fagbemi, and also FRN versus Ifegua, where convictions were nullified for being founded on non-existent law. The Constitution remains the supreme law of the land. Kanu said any act done or decision taken in violation of its provision is null and void. In his motion, Kanu urged the court to compel the prosecution to respond strictly on points of law within 3 days and for the presiding judge to deliver a ruling on or before November 4th. He emphasized that his application raised pure questions of law and constitutional interpretation, hence did not require any supporting affidavit. According to him, he says, my application is strictly legal and constitutional. It involves no factual controversy that will require an affidavit. Now, for the benefit of those who may not understand exactly what Nnamdi Kanu, this fresh case, what he's actually filing, let me give you some key points about it. Now, number one, he is saying that there is no valid charge existing under Nigerian law. According to him, he says that the 7-count terrorism charge is based on repeal section of Terrorism Prevention Amendment Act 2013, which were replaced by Terrorism Prevention and Prohibition Act of 2022. In other words, whatever the 7-count terrorism charges were based on 2013 law, which has already been substituted with the new one, which was brought into bear in 2022. He further said that the alleged offenses, example, incitement, unlawful broadcast, membership in terrorist organization, do not exist as crime under 2022 Act. This guy is smart, I must say. Now, the second one, he's saying that the indictment is legally void. What it means is that since the charges rely on non-existent provision, the entire prosecution is null and void. In other words, what he's trying to say is that since you people were relying on Terrorism Prevention Amendment Act of 2013 and it has been replaced, so it therefore means that there is the whole indictment is legally void because the prosecution was based on that 2013 Terrorism Act. Now, the third thing that he said in that filing, he says that he's demanding for immediate and unconditional release. He's seeking dismissal of all charges and his immediate release from DSS custody, arguing that no prima facie case exists under current law. This is smartness. Number 4, rendition illegality reinforces nullity. That means that though not the primary ground, that the motion references his illegal abduction from Kenya in 2021, condemned by UN and Kenyan court as further proof that the trial is tainted. The fifth key point of his filing is statutory interpretation argument. He cites section 36 subsection 5 of the 1999 Constitution. A person shall be presumed innocent and cannot be tried for an act that was not a crime when committed. And he make reference to the 2022 Act decriminalizing the act alleged. So right now the bottom line is that Kanu's team is not challenging evidence again. They are saying there is no crime to answer for because the law used to charge him no longer exists. If upheld, this ends the trial without needing a further defense. I don't know how the federal government will handle this case right now, because I must say that this is going to be a shocker. November 4th is on the way, and if James Omotosho consider this new filing by him, I think Nnamdi Kanu should be released. Let me allow you, let's meet in our conversation and talk more on this. Thank you very much and stay tuned.
Is it for ChatGPT too?
Mm-mm.
Is this your last